Hello friends, Namaskaram. How are you? Myself is Dr. Jinesh Soni. I am an advocate. In today's class, we will take an important topic for discuss. The problem is too much common, but the problem is technical in nature. First, we have to understand the problem. If in a case under Prevention of Corruption Act, the sanction is refused, whether the public servant could be prosecuted or not. Is it possible to issue a fresh sanction based on same material by the same authority or by the authority hired to that authority? And what are the basic principles regarding issuance of sanction as per section 19 of Prevention of Corruption Act? So we are discussing all the concern, but in a step-by-step manner. I request all of you to maintain a proper notebook along with pen or pencil so that you could maintain your information in the proper way. So whenever you are having the problem, there is no need to go to advocate office. Just open the register and try to resemble your problem with the material in your possession. If you are having the solution, then there is no need to go for the consultation or for the review. So first of all, we have to note down two important judgment of Honorable Supreme Court. Number one, State of Punjab versus Iqbal. Judgment is pronounced in the year of 2009. Another one is State of Himachal Pradesh versus Nishant. It is pronounced by Honorable Supreme Court in the year of 2010. In both the judgment, it is specified that sanction, once refused, cannot be issued again on same material. I'm going to emphasize on the word on same material. So simply we could say if the fresh material or new material or additional material is brought on the record, in that scenario, a fresh sanction could be issued. But it is seen that in the routine way, due to certain political agenda, a fresh sanction is issued, even though it is refused by the authority competent. Then what we can do? In that scenario, we have to understand the three important principles of law. Number one, no fresh sanction can be issued without according you the opportunity of being heard. As we know that the adverse action cannot be taken in absence of being heard. So if the opportunity of being heard is not given to you, you may challenge the fresh sanction on that point itself. Because directly or indirectly it is going to infringe Article 21 of the Constitution. You got my point now? Now it is easier for us. And if inter alia it comes to our kind knowledge that the higher authority is going to issue a fresh sanction, you may submit your objections. And even a prayer could be made to hear you before issuing the fresh sanction. If the opportunity of being heard is not given to you, if the material submitted by you is not going to be considered, even the law point submitted by you is not going to be considered, and the order is in limine, means in short, without specifying any reasoning. In that scenario, we could challenge the order in the light of judgment of Honorable Supreme Court. That is Inderjit versus Santosh. Judgment date is 19th of April 2022. You got my point? Number three, despite of your efforts, if a fresh sanction is issued, you may challenge the sanction before Honorable High Court. For this, you are required to file the writ petition. But in the writ petition, you have to specify the fact in the following four categories. Number one, the brief facts about the case. From where you could get the facts? From the FIR. Number two, the refusal of sanction. Number three, any memorandum submitted by you at that time based on the same, the order of refusal is passed if you are having the same. And number four, the objection submitted by you and the reaction of the authority on the same. If there is no reaction, the order is passed in the anxiety without hearing you, and it is in limine without any reasoning. These are the additional circumstances which could be averted in the repetition so that we could be succeeded in our argument. Remember one thing. Before Honorable High Court, we are having a very short time. So we have to specify all these things. We have to specify the violation of law. We have to specify the approach of authority. And we have to specify that the approach is totally illegal. It is in abuse of process. I am remembering the name of a person named as Shailendra Kumar Gaur, who is having the same trouble. Ultimately, he has filed a petition before Allahabad High Court. The matters listed before the court, he relied on the two important points. Number one, the sanction once refused cannot be issued again on same material. He submitted that in his case there is no fresh material, and that's why the reissuance of a fresh sanction based on same material is nothing but abuse of process. And apart from that, he relied on judgment of State of Himachal Pradesh versus Nishan, which is pronounced by Honorable Supreme Court in the year of 2010, and finally he got remedy. So in the similar way, you may put up your case and could obtain remedy from the competent court. But you are required to follow the step. You are required to observe your entire proceeding so that you could chalk out a case for the intervention. But I request all of you, do not do the pleadings in the anxiety or in the general way, because you have to specify your case. You have to specify the violations. And in case you failed, you could not be succeeded. See you in the next video. Till then, Har Har Mahadev, Jai Shiv Shambhu.